Good afternoon, everyone. Welcome to our second event to the App Makers Tour of Europe. After Romania, we're now in Germany, and throughout 2021, the App Association is virtually hitting the road on its App Makers Tour to bring together local app developers, policymakers, also industry leaders to have this open conversation about today's app ecosystem. And this is a particularly important moment because we are in a context where legislators in Europe, but also around the world, as a matter of fact, are discussing new laws targeting global online platforms, including app stores. And in Europe, this is taking the form of newly proposed legislation by the European Commission called the Digital Markets Act, the DMA. So in this context, we wanted to bring the on-the-ground experience and the perspectives of our members in this debate, and to talk about how we can create this environment where businesses and innovation can thrive, and this to the benefit of consumers all around Europe. So we're particularly grateful to have distinguished speakers today on the panel with policymakers directly working on the legislation. So Dr. Andreas Schwab, rapporteur in the European Parliament on the Digital Markets Act in the Internal Market Committee, and who will join us, I hope, a bit later. We have also Dr. Kaiserberg, Head of Competition Unit in the German Federal Ministry of Economic Affairs and Energy. So in terms of app developers, we have Lisa Figas, who will join us only for the panel, and she's the founder of App Telemetry, an analytics tool for app and web developers that's heavily based on privacy. And from the industry, we also have Rebecca Weiss, Head of Security and Trust at Bitkom, trade association representing the digital industry in Germany, which includes thousands of SMEs and over 500 startups. So before we'll start the opening remarks, I'll just give the floor to Mike Sax, the founder of the App Association, for a quick welcome. The floor is yours, Mike.
Thank you, Morgane. It is very great to be here and to have so many smart people in one virtual room, so to speak. At the App Association, our members, make apps and devices, and they are part of the app economy. Without apps, this phone is very boring and not very useful. So they make wearables and mobile devices really useful and valuable for people and for companies. The startup and SME scene is especially important today, and we've seen a lot of really good success. In 2019, the top German startups accounted for 9.1 billion in funding. So there has been a lot of investment, and we need to make sure that that continues to happen. A lot of German startups have become huge success stories. There is N26, the fintech app, the e-commerce companies, Zalando. There's the HelloFresh, which is also a German company. And even though Berlin has consistently been one of the top 3 digital hubs, these apps are really made in all parts of Germany, and they create opportunities both for founders and for employees to work in a part where they can stay connected to their family, raise their kids, and at the same time reach a global audience through these app stores. Apps, it's hard to imagine what this horrible pandemic would have been like without apps. Apps have played a key role in allowing us to keep life going and work and study and stay in touch with our loved ones, and even, order food or clothing, even though we haven't bought that much clothing these days, staying at home. But all these things have been made possible through apps. And now we're using apps to, make sure that everybody can show that they're vaccinated. The Digital Market Act is, I think, one of the most important regulations to be enacted in our time. And we appreciate the recent draft report from MEP Schwab, which recommends several changes to the original DMA proposal from the Commission. Many of those changes we fully support, and in particular on the need to involve more third parties in the consultation and the regulatory dialogue process, so that everything can keep running smoothly, and input from the whole community, the whole ecosystem can be considered. We've been doing this App Makers Tour to bring policymakers and app makers together, so that we can have a conversation and think through the impact of these new regulations on local developers. I'm especially grateful for MEP Schwab and Mr. Kazenberg to be here and take the time to participate in the panel discussion, because app makers are often the topic of discussion, but we're not always part of the conversation. And so you taking the time here is really very meaningful for us, and I think it will result in really great insights for everyone involved. We don't know fully what the impact of all the new obligations will be. I'm sure there will be unintended consequences on such a big regulation. There almost have to be. But having this kind of conversation, having this dialogue, I think will be, tremendously useful. We have some brilliant minds, and we have, many different perspectives together. So I am very much looking forward to this conversation, and maybe let's just dive in right now. Thank you.
Thank you, Mike. So let's jump right in for the opening remarks. So how will the DMA regulation impact smaller businesses, and will there be any unintended consequences for this regulation? Dr. Schwab, you have recently released your amended version of the DMA. Can you highlight some of the main changes you've made to the proposal?
Well, Morgan, that's with great pleasure. Thanks, Mike, for the invitation, and thanks also for reaching out to app developers, because it's of utmost importance that this legislation is part of a broader try and aim of the European institutions, of policymakers, not only in Brussels, but also in capitals in the European Union, to make sure that digital is a driver for innovation, is a driver for business, and helps to move on in the economy. And therefore, these laws should be in the interest of everyone. They should help to make innovation flourish again. They should create fairness and competition in the marketplace. And they should look for everyone to be able to have its own business in digital, as in offline, in the offline world. And we want to contribute to that. And therefore, I think it's very timely that we meet today with the Germans, because the 17th of June in German history is a special day. It has been in the past the day of German reunification, because the communists in the eastern part of Germany on the 17th of June have started to close down their socialist project. And they have tried to show that you don't need several jobs in a town. It's enough if there is only one. You don't need different shops. It's enough if you have one. And if you have one shop who has everything, you will be happy. And this was a great, stupid idea, because no one was happy. In the end, there was nothing anymore left. And therefore, monopolies and state planning is a nightmare. And therefore, we should be scared of monopolies, because competition, and it's true that competition purely might also lead to wrong developments. Fair competition is the key to make businesses happy, but at the same time also the people that are living from businesses, that are using the services and they enjoy to buy in these offers. And therefore, I think our utmost goal has to be together to make sure that the Digital Markets Act can satisfy that idea of creating fairer markets and a long-term vision for innovation, for business, etc. That's what I want to contribute, and I'm looking forward to your opinions, to your input. And then if I have to change my report further, I would very much looking forward to your proposals to make it better. And this is not because I'm looking for lobbyism. I mean, I'm a lobbyist myself for the best legislation possible. And whoever wants to contribute is very welcome. And that is not lobbyism, that is purely democratic contribution in a decision-making process of policymakers. And you are very welcome here. So thank you so much for your attention so far.
Thank you very much for these remarks. We're looking forward to an interesting discussion. So maybe now I'm going to turn to the ministry the Ministry of Economic Affairs and Energy. Dr. Kaiserberg, what is Germany's position at the moment on DMA, and where do you see improvements of how we can make this report better for SMEs in Europe?
Many thanks, and sorry, I think you just couldn't see me in the beginning, but I've been listening to what you've said. So many thanks for the invitation. And indeed, I think apps and app stores are really an integral part of the digital economy. And I think when we did our national competition law reform in Germany, we listened, and of course, there have been stakeholders raising their voice, but I think it's really important, in particular in the context of the DMA, that app makers get their say. Now, Andreas Schwab has already made the historical analogy to speak out against monopoly gatekeeping positions. I think you've already jumped to the point where you asked where we could see improvements on the DMA proposal by the European Commission. So I don't go back into history too much, but one thing I wanted to say is that irrespective of where the nitty-gritty details of the DMA will go to, the German position and the German government's position, at least for a number of years, has always been that we need more than just competition law and more than just abuse of dominance law. The European Commission and also some national competition authorities have tried to use existing competition instruments. It has been, all of them have rightly been to some extent praised for going ahead, but at the same time, I think there has been now really, there is a majority position that this is not sufficient, both in terms of length of the procedure and also strictness of the rules. And that's why the German position has been advocating for legislation on the European level, because we talk about the biggest companies in the world. So just in essence, on a, let's say, very a nutshell level, we are happy that the Commission has tabled this proposal. Now, if you asked for further amendments that we would like to see, I think one specific point is that, and that goes back to what I tried to say before, that we would need some sort of clarification with regard to a competition law and competition authorities. I think it's natural, and that has happened before in other areas of the economy, that once you have bottlenecks, you have big gatekeepers, competition law in the beginning has been used to sort of regulate those bottlenecks. And as I said, I mean, due to time constraints, resource intenseness of modern competition law, that does not suffice. So at the same time, I think the DMA is not exactly a competition law, but we need to clarify further in the draft how the cooperation between future enforcers and competition enforcers will be. I think the Vice President now seems to use the picture of a river, and the DMA is the sort of the sort of first a wall or net against the biggest abuses, and then behind that there is the second net of competition law. That's, I think, a good picture. But to implement this in practice, we need more concrete rules on how competition law and the DMA will interact. I think another point that relates to that is that the German position is that with the 80 people envisaged in the European Commission, that will just not be sufficient, given that we talk about the five biggest companies in the world. And that's why we have tabled a proposal how to make use of the existing resources in national competition authorities. We understand that there is to some extent a skeptical look on competition authorities. At the same time, there will be all the law firms in the world that can be hired by the gatekeepers, and they will be put on those cases. So we need a lot of bright and competent people, and we think that to some extent they should come from the competition community. And my final point, just as an opener, I think where there's, and we said that a couple of times before, where we think there is really a blind spot in, let's say, the whole approach is we really talk about market structures. And if we talk about market structures, we have to talk about remedies, and we also have to talk about merger control. For us, we just don't really understand why the Commission has been here so shy, because the merger regulation has been evaluated a number of times over the last couple of years. The whole DMA is based on the internal market base, saying that there is, for example, German legislation, other potential legislation. And on the other hand, we hear that on merger control, we can't do anything because of the legal base. And to us, this is not convincing. We really think merger control must be part of a solution.
Thank you very much for these opening remarks. I'm going to, we'll be able to talk about this a bit later, but I'm going to turn to Karen Morley. Thank you for joining the event. So I'm turning now to the developer's point of view. So you've been experiencing firsthand some of the benefits and the challenges in the app economy. Can you maybe present, highlight what your app does and what was the business journey behind it, and some of the maybe the challenges or benefits that you're getting at the moment from the online ecosystem?
Sure. Yeah. So thank you so much, Morgane, for having us here. Yeah, I'd love to share my screen to show you some slides. Can you see my screen okay?
Yes, we can.
Okay, so hello, my name is Kareem Morsi, and I'm the CEO and co-founder of Algorithm. We're based in Munich, and we co-founded the company almost exactly 15 years ago.
You are the one who is doing all the algorithms. Now I understand.
Yeah, exactly. And we make, so this is our flagship app. It's called DJ, and as the name implies, you can probably guess what it does. It's basically an app that allows anyone to become a DJ and interact with music. And basically, it's kind of the first step from being a listener to being a more creative person with music. And we've been innovating for over 15 years now across different platforms. And we've been the #1 app on the entire App Store in 100 countries when we launched. And to date, we've received over 50 million downloads around the world. So this is where we are today, but I'd like to take you back in time. Since we started really early on, we can consider to be kind of like the dinosaurs in the app business, because we've been there even in the pre-App Store era when apps weren't even called apps yet. And I'd like to take you back in time here to give you a little idea of how it was to sell and purchase software back then. So first of all, let's take a look at a developer perspective, and that's selling apps, quote unquote. So you basically had multiple challenges. First of all, it was distribution. So we were actually selling a boxed product. So when we created software, we didn't just put it on the internet, we have to print boxes and then put it on a CD. And it was very complicated because we had to set up distribution for each country individually. We had distributors, aggregators, a lot of middlemen in between. And it was quite complex to set that up and get our product in stores around the world. And of course, we also had online hosting. So we also had our own store where we had to process credit cards and all of that fun stuff. And it was quite cumbersome for a small app developer like us back then. We actually founded the company out of college. And then there was marketing. It was really hard. Like, how do you find visibility for your app? Because it's not enough to create a great, amazing app. It's really, this is only where it starts. Then you have to market it to people. So we were actually flying to trade shows around the world. Like here you see a picture when we had our first booth at Macworld. Was insanely expensive, but back then I think we spent like almost a fortune for our conditions back then to promote our product there and find an audience. And then you had magazines where you could print ads and all of that fun stuff. And then I would say that was our biggest challenge in those times, was piracy. Because we were not just competing with products that were similar to ours. We actually had to compete with our own product. We were selling DJ for 50 euros, and there were illegal torrents and websites that offered the same product for free. And it's really hard to compete with that. And it was in fact really cannibalizing our sales. Now let's take a look at what it meant to buy an app on the pre-App Store era back in 2006 and 7. So first of all, you had to find the app. And that by itself was challenging also for the customer because they had to browse countless websites to find the right app. And for example, if you Google DJ software, you get 614 million results. That's not quite useful. It's really who's the best in playing the SEO game, and not necessarily what is the best product that appears at the top. And then you had to purchase the app as a customer. So for every app that you buy, or every software, I should say, you have to enter sensitive data. On arbitrary websites, every developer has its own thing and you don't know about security. And just getting from the step of, I want to buy this app, to actually purchasing it, it was a couple minutes that you actually had to fiddle around with your card and your details. And that was only half the story, because then you would get an email from the developer, or you would open the box, you would get a license code. They're typically very error prone. And then you had to do an installation, and it was all quite cumbersome to get that right. So even from a user's perspective, it was very challenging to just find, purchase, install, and register an app. And then came the App Store, and we think, you know, when the App Store came, it really solved all of those problems and changed everything for us as developers. And quite frankly, we're confident to say it was a true revolution in software distribution and consumption. Now, how did that look? So this was the new flow. You could now purchase apps with a single click through a trusted store. And it was one place where people already had their credit cards, and they knew, you know, they can safely trust Apple to purchase apps there. So what really was the game changer for us and for the customer was you hit the get button or the buy button, and that's all of the friction you really had. And when we launched on, I think the 3rd of December in 2010, overnight, we basically made it to the #1 spot on the App Store, even beating Angry Birds for a few hours, as you can see on the right-hand side. And it was a tremendous success that would have not been possible, you know, with our sort of amateur, you know, SEO optimizations that we were doing back then and showing up at trade shows. Now we were center stage in the world of software, right in the top 10 of the entire App Store. And of course, downloads skyrocketed. So as you can see in the timeline here, we launched the Box product in 2007. Our users were pretty much in the thousands. And when we launched the first version on the App Store, we went from niche to mass market, and we went from thousands of users to millions of users. And as you can see, and this is really special, it's not just the quantity, but it's also the range of people that we could now access, people that wouldn't necessarily even search for DJ software in the pre-App Store era. So from little girls and boys that want to experiment with music all the way to world-class musicians like Justin Bieber's DJ, who would use it in front of 80,000 people. And you can also see here on the right side, that's DJ Arch Jr. He even made it into, he started DJing on an iPad with our app when he was 2 years old because he found it randomly on the App Store, his father. And he made it to the Guinness World Record as the youngest DJ in the world. So it's really heartwarming to see how many people we were able to reach and in fact change their lives. Now, finally, let's take a look at the business perspective. So we're available across all platforms, Mac, Windows, iOS, and Android. And we're clearly seeing on the App Store by far the highest customer lifetime value, you could say by a factor of 10 and more. And we believe that's because it's the minimal purchase friction. It's a unified distribution model for us, so we can be very, very efficient as developers. As opposed to other platforms, we don't have to submit an update on multiple different stores, but it's just a single store. And it's also the security, because in fact, we no longer have to deal with piracy, where people just Google for our product and then they find it elsewhere, because it's just much, much harder with the given setup. Yeah, so that was a little presentation and a little journey how it went for us, and I'd like to thank you for your attention.
Thank you very much, Karen, for this presentation, and it's exciting to see how your app grew. And but now I'm going to turn to Rebecca for also the industry perspective, but it's more in a general sense. So Rebecca, can you tell us a bit? You represent many businesses in the digital environment in Germany. So can you tell us a bit more about, back to the DMA, a bit more of some of the things, that some of the concerns that you have today?
Sure, thank you, Morgane, for inviting me, and thank you to all the previous speakers for the valuable insights you have already given. And I would like to come back to what you just said, Karim, because it's something that has been the center of our discussion at Bitkom, and especially regarding the national competition law that Dr. Keseberg already mentioned. And that is, if we regulate competition, there are almost always consequences that we did not intend when we were drafting the law. That's why there were quite difficult discussions around the national competition law that we reframed a bit last year, and which ended into force at the beginning of this year, and I guess which will also be the center of the discussion in the coming month for the DMA, because what we see is that the DMA is basically targeting a few companies and a few challenges the digital environment and the digital ecosystem has brought with it when it developed and has been developed further over the last 10 years. So we are often quite focusing on a few issues, and as Dr. Keseberg already said, there were already a few competition cases, of course, but what Karim just showed us is that, what the other side of the equation sometimes looks like. So if we look at some issues only from one perspective, then we see only some problems, but the ecosystem, especially the digital ecosystem and the platform ecosystem, is so highly interconnected. There are so many dependencies going on that sometimes if we pull one string, everything just falls apart. And I think we made really good progress with our German competition framework. There are a few safeguards in there, but for everyone who doesn't really know all the details about the German competition law, it is in the end still a competition law, and the DMA really isn't. That might lead to some problems, which is basically what we are focusing on right now, because we think it is basically a good idea to find new regulation for fair competition, and there has a European approach, because for all companies in the European market and in the global market, it is absolutely beneficial if we have harmonized rules. So for us, it was a good step to find national legislation and to reframe our German competition law a bit, but it's a necessary and it's a good step to think about competition law, fair competition, including more players in the digital ecosystem on the European level. So the DMA is a good idea. But there are a few things missing. We would like to see clarification for the regulatory dialogue, for instance. I think it's absolutely necessary to include more players into the dialogue. I think that was already very rightly mentioned already. And the interdependencies and the connections in platform ecosystems are not well enough based in the provisions that we have in the DMA, especially in the prohibition articles 5 and 6. It's a bit too broad. It should be a more tailored approach that really only focuses on some issues, and all prohibitions, of course, should take the specific business models into account that they are intending to regulate. So we hope that we don't see too many of the unintended consequences that we'd like all to avoid in the future. And what we also think is necessary, because of all the interdependencies on the platform ecosystems, are some safeguards, because if we look at the DMA, we are talking about ex ante regulation. It's a new approach, if you want to call it that, especially in a competition context, and safeguards for security, some efficiency safeguards as well, may help counteract consequences for the ecosystem. So we might achieve what some want to achieve, so regulate the largest platforms we do have on the globe, but I don't think that's the only goal we have here. What we all want is more competition, more players in the market, and a fair game. And sometimes if we hit the largest, then that might have some consequences for them, but it might also have a ripple effect and trickle down the digital ecosystem. And I really hope that we'll try to, or that we'll achieve exactly that, so that we'll get more safeguards, a bit more clarity, especially regarding the dialogue. And of course, Dr. Kesselberg already mentioned that as well. It's absolutely necessary that the competences and the authorities are included, especially also on the national level, because we do have many smart women and men in our national competition authorities, and they should be included, because we do also think the Commission won't be able to handle all that with only 80 more people there.
Thank you, Rebecca. I think you touched on many points that we echo. Before we move into the panel discussion, MEP Cavazzini regrets that she couldn't make it, but she did send a short video. So I'm going to play it now, so you can prepare for the panel discussion. So here is MEP Cavazzini, and here you go.
Thank you very much for the invitation to speak at your conference. I'm sorry that I cannot be there in person, but I'm delighted to have the opportunity to send this short video message. It is very exciting times in the digital sphere, with the Digital Services Act, the Digital Markets Act, but also the new regulation on artificial intelligence, which is the first of its kind in the European Union. We have the unique chance to set strong standards, even probably global standards, for the digital single market. We saw in the past a fragmentation of the digital single market because member states starting to come up with their own legislation. We saw tech companies, big platforms dominating our lives, deciding themselves what we as consumers see. We saw that small companies didn't have a chance on the digital markets. So with the upcoming legislation, we have the ability to really correct how the digital single market is working, to also harmonize and make sure that we stay in our internal market connected, that borders are not existent, that businesses can act all over Europe and trust our common European standards. I think it is a unique chance also for the European Union to set standards according to EU values. For example, democracy, freedom of speech, but also consumer protection, which is very important also for my committee, the Internal Market and Consumer Protection Committee. I'm really looking forward to the debates and the discussions we are having in the European Parliament, in our committee at the moment, with the different amendments, the different ideas that are floating around. I would really appreciate and find it as an important goal to have a strong legislation that is working at the end for businesses, but also, of course, for consumers, for users of those platforms. I think we also have to make sure that the enforcement architecture is right. We see it often that there's very good EU legislation, but then we are lacking a little bit behind when it comes to enforcement. So in all of these debates, we have to also discuss how do we best enforce these kind of legislations. I wish you a very, very fruitful debate and all the best.
So we talked about the different obligations. Rebecca, you mentioned the fact that there are independent ecosystem. So I'm going to turn firstly to Karen to talk about the concrete obligations, what they will have as an impact on your business. And since you're an app developer, I'm going to talk about those that relate to app stores. For example, one of the DMA's recommendation is to increase competition. Is to multiply the number of app stores by allowing sideloading. So I'm just wondering what, for you, the mandated impact of sideloading of different app stores will have on your business. For example, are there specific challenges when that you face when trying to launch the same app on multiple app stores? Or let's say, what will it do to your business if you have not 1, 2, or 3 app stores, but 10, 100 app stores and so on? So I just want to maybe to have your thoughts on that.
Sure. Yeah. So for us, I think multiple app stores would clearly be a challenge. In fact, we're already seeing that, or have been seeing that on Android, where we were on multiple app stores. So there's the Google Play Store, and then there was the Amazon Store, and we just realized that it doesn't really add much from a business perspective. It just adds fragmentation, because every app store then has their own rules, and it's just very challenging, because today, you know, the operating systems keep evolving on a very fast pace. So every year you have a major Android update, you have a major iOS update. So we have to constantly stay on the cutting edge and provide updates very frequently. So having multiple stores just increases the complexity. And again, if you have other stores where there is not so strict curation or a review process, if you will, then of course you have the issue where people just they copy intellectual property, be it your trademarks, or even just outright taking the binary and putting it on that store. Then again, we're kind of going back to that pre-app store era, where we then have to compete with our own app that is just put on a different store. And again, just from a user perspective, we also think it adds a lot of friction. That's why even we have our own online store for our Mac version, but we actually decided to not even offer that to the user and just on our website direct them straight to the Mac App Store, because it just adds, you know, it gives them a choice where they may not even want a choice. They just want something simple. And we want to really minimize that point where they decide they want to get our app. We want to minimize the friction. So it's a multitude of reasons of why we think the simpler, the better, both from a development cycle perspective and from a user perspective.
Okay, thank you, Karen. I'm just going to ask also Lisa, for example, so App Telemetry is a new app analytics service that aims to help app developers really analyze how the users use an app. So most analytics packages are mostly collect a huge amount of data for all the users. So this has both ethical and practical problems. Because consumers' trust is an essential element behind the success of the app ecosystem. So the DMA also recommends that devices allowed in installation of like app store builds for siloed apps. I'm just wondering from your perspective, for example, are there like you deal a lot with privacy, are there security risk, are there things to be improved? How and what do you see the benefits, for example, to be of the different, I would say, ecosystem?
I think Karim summed it up pretty good, that users want to have it simple and want to have like one place to go per device, so that they need that they know where they find their apps and they can look for new things to discover. But from a developer point of view, we think that like opening up I'm mostly talking about the Apple ecosystem because that's what I know best. So opening up the App Store like a bit would be best from our perspective. So think about the notarization system that Apple provides for the Mac OS apps or software you can install on your Mac. It gives some kind of certificate to the software before you provide it on your own website or wherever you want to download for the users to install on their Mac. And if their malware gets detected, Apple has the opportunity to shut down this software on all Macs where it is installed, which is, kind of an insurance for your users. And we think that something similar would work on the App Store too, because it would open up the ecosystem a bit, but only for the skilled users or the users that know what they're doing. So we are not like thinking of different app stores. I think Karim is completely right that it would lead to a lot of work for all developers. And since we're at App Telemetry mostly in contact with indie developers and pretty small companies and single person providers, we think that this would cause a lot of confusion, harm, and a lot of work for those people.
Thanks, Lisa. So for example, some of the applications could have, even if they were intentioned, could have some unintended consequences. So then back to you, Dr. Schwab. We appreciate reading your draft report that you made specific provisions for interest parties, third parties, such as smaller app developers, to participate in this regulatory dialogue process and market investigation. So maybe hearing, like, for example, from SME perspective, that everything will not necessarily work for them, could you explain a bit more detail how app developers could provide their feedback to the solutions in the DMA, and how do we ensure that SMEs are able to participate in this conversation moving forward?
Well, I mean, the first point seems to me that the presentation that we have been hearing here is very clearly putting the finger on the fact that for the developer, a centralized or even decentralized system is the most convenient one. And I do understand that, but that's not competition. So I think we have to take into consideration that for developers, the gatekeepers have offered a huge opportunity to go to the market much easier than ever before. But still, the gatekeepers are no public utilities. It's not state-driven institutions. They have interests to earn money, and where they can do it without control, there is a risk of a monopoly. So the argument, the consumer like it and it's so practical for us, unfortunately, it's not the point here. We speak in the DMA about contestability. But I see also that in that debate, there are plenty of people saying, but Apple is earning too much money. They should be bothered. No, I mean, it's true. And I'm very grateful for Karim to show how much has improved the possibility for app developers, for SMEs, to go to the market just by getting a client account with the Android App Store or with the Apple App Store. But still, these two app stores, they have to be open. And for example, there is an app developer, maybe one from your association, that has developed the app Disconnect. And that app, surprisingly, has not been offered to run on Android. Why this? Because Android has said there is too much transparency that Disconnect creates about tracking apps, and therefore we don't want to have such apps on our system. And that is a good example how these app stores have an obligation to neutrality and have to respect contestability of markets and fair competition. And that's what we want to enforce. And I personally would be very happy if there would be a third or a fourth app store as well. But you cannot bake them, you cannot create them, they have to grow, and for the time being, I don't see them. The other side, however, is that the rules that we have to do for the app stores have to be fair as well in relation to them, because they are not a free lunch that you can eat several times. They have invested in this for their own business, because people that use the iPhone can profit of this, and the developers can go there, but we cannot oblige these gatekeepers, these app stores now, to offer everything for free. They are allowed to earn some money with their service. The question, however, being what is the fair amount they can earn and what is the contribution to contestability that they can offer. So I would say that my report is quite balanced on this. I think they have to be neutral. They cannot block or ban specific apps, except if they create a cybersecurity risk. There have to be fair costs. There is in some areas some questions, but as Karim has pointed out, there are some questions, but it's not, from my point of view, an area where we can say today, this is absolutely unfair. There are some marketing tactics that I don't really understand, and where we may shed some more light, and where the Commission may able to be to act. But generally speaking, I think it's obvious that the app developers like these systems because they facilitate the life for you. But the problem is that, and this is a bit the key for the next question as well, that has been brought to my attention through the Q&A. The key problem of these digital markets is there where there are ecosystems, where you can have, when entering one core platform service of a company, that you can be directed to the second and the third and the fourth of the same company. And like that, they have an interest not to show you the choice that you could have, but to show you only the choice, like in Eastern Germany, that is in their shop. Now, to be honest, their shops are a bit nicer than in Eastern Germany, but still, you may see something nice outside, and that is blocked to you. And here is a bit the role for policymakers to make sure that this outside view is not completely covered. That means that we have to find the right way to deal with it. And this is the second question on that Q&A. Inter-platform competition has to be possible also in the future. And this is not easy to be, let's say, foreseen as a policymaker, but that is our aim. And the concern that is brought to my attention there, the concern that some of the provisions of the DSA appear to harmful for potential inter-platform competition, is something that we have to consider further. I would be very happy if you could outline that a bit further. And on the question one, the proposed amendment to increase the thresholds, I believe that we should not now try to create a law, as Mr. Käseberg has rightly said, where there are 80 people at the European Commission, maybe there are some more, but in the end, roundabout, there are 300 in Germany and 200 in France, and all the others are quite small. And then we say to the public in Europe, now we control all businesses if they are a gatekeeper. This is not serious. It is just impossible. And we should also try to make clear that this is just fake legislation if we would vote for that. We have to say, we have to fix this law where we need it. And we don't need it as a second competition policy proposal because we have competition policy. We need it where competition policy comes to an end because it cannot work anymore in the time that is needed. And that's after the comments of Tommaso Valletti, the former chief economist of the European Commission. That's only needed for two companies that I don't want to mention here, but these two companies are the companies that have the highest level of ecosystem interference or interdependence, sorry. So the DMA is there to fix some specific problems in the digital markets. And the DMA doesn't care about where the companies come from. The DMA just cares about the ecosystem with the tipping element of markets, nothing else, nothing more. And for that reason, I think the proposal to raise it to 100 billion is more than fair. I mean, Morgan, I don't know when you speak about 65. Probably when you think to go to pension, then the number 65 comes to your mind. But normal people don't speak about 65 for gatekeepers. They speak about 100 billion or about 200 or maybe about 50, but never about 65. This is just crazy from my point of view. And therefore, it would be a bit fake to speak about 65. The level has to be somehow very big. Now we can discuss, is it 50, is it 75, is it 100, is it 150, is it 200, or is it 600, as the Americans have now put the threshold? Because the American bipartisan bill that is now in Congress is foreseeing 600 billion. That is really only the GAFAM, no one else. With Europe's threshold of 100, we are close to also other companies that could be emerging gatekeepers. And by the way, the Commission can always address emerging gatekeepers. Therefore, this debate is a bit misguided. And therefore, also the 100 billion threshold is something that helps. But the question here is more about the proposal to say they have to have more than one core platform, so at least two. Why this? Because as I said, for mono core platform service businesses like Twitter, like TripAdvisor, you don't have the same problem with the application of competition policies compared to the fact that there is an ecosystem behind one company. Let's imagine Facebook, there is Instagram, there is WhatsApp. There you have a bigger problem to find an alternative. On WhatsApp, yes, you can go for a Signal or for Wire or for whatever, but most people are on WhatsApp. That's a problem. But secondly, Instagram and Facebook, there is no alternative. So the fact is that on mono core platform service providers, there is a chance to fix the problem with competition policy. This is more difficult with ecosystems, and therefore I think the presumption what a gatekeeper is should start with the fact it's a very big company, and it has more than it has at least two core platform services. And now coming back to the point that you have been asking me, Morgan, what can be done for app developers to get in touch with a dialogue? Honestly, I don't know what Karim does the whole day. He's not thinking about calling a competition authority. He's improving his app. He wants to do his business, and he wants to have other people caring him to be free of negative interference with gatekeepers. If there is a problem and he's really desperate, then he needs someone that he can contact with quickly and fastly. And there we have a network in the European Union with the European Commission on top. And that should be useful, because if he has been detecting the problem, it's very likely that there are people in Portugal or in Spain that have the same problem. But if not, then it can be done by the German competition authority. If not, we have to do it together. And there is no problem, but we should not give the impression that app developers need the competition authorities to call. They have other stuff to do. They earn more money with their own business than complaining about the others. And like that, we should organize the market that they are free of this. And and I think like that, we have to make sure that competition authorities work constructively together.
Yes, go ahead, Mike.
When talking about monopolies, we, in this conversation, we often talk about like the iOS App Store monopoly, and then the Play Store being so dominant is also kind of a monopoly. And if you look at the evolution of those app stores, they are interacting with each other. They're responding to each other. They are, you look at the new things that have been introduced, from in-app purchases originally, and then subscriptions, and then featuring apps, and all these different capabilities. They have been competing with each other all along, and they continue to do so. And the pace of change and innovation is very hard, is very, very high. So if you have two monopolies that are fiercely competing with each other, they're not really monopolies, they're competitors. And I think if I'm an end user, I have a choice what kind of device I want to buy. And in Android is a little bit, is quite a bit more popular in Europe in terms of number of users than iOS. In other parts of the world, sometimes iOS is more popular, but that is true competition. And I hope that in the next few years, a European company will come and emerge and become the leading maker of devices and have their app store on their device as well. I think it's entirely possible. There are so many tech companies, from CompuServe or MySpace or whatever, that we don't really know anymore or hear about, because they were dominant and they looked like monopolies in their time, and they instantly vanished. So this is a very dynamic area, and the situation could completely change, and Apple or Google could be, part of tech history 10 or 20 years from now very easily, or maybe even less than that. So monopolies, is a concept that we have to look at in the modern context, and not in a context, from industry with railroads and big manufacturing plants and everything else.
Thanks, Mike. I saw Dr. Kazabek's not necessarily agreeing with everything, so I'm going to turn to you now. Indeed, so this year, for example, Job Empowerment adopted its own law to address certain practices by companies of paramount significance for competition across markets, and this is obligations that are applicable on a flexible and tailor-made basis. So I was going to ask you, in comparison, do you think the DMA currently provides for enough flexibility, considering this heterogeneity of digital business models and the dynamic nature of these digital markets that Mike was talking about?
A great question. I think it's a trade-off between, on the one hand, as Andreas Schwab has said before, that we need certain specific rules against behavior that, at least as a legislator, we have identified to be harmful, and also to sort of protect investment by all the companies involved. And on the other hand, being flexible enough to actually achieve, I mean, that's one of the biggest aims of the DMA, to speed up sorting out bad practices as compared to competition law. And we think that right now the balance in the European Commission's proposal is struck quite well. So we've also heard about proposals to further flexibilize the mechanisms. Actually, we are quite, in that regard, we are quite happy with the existing possibility for the Commission then to go to the foreseen mechanism and procedure. I don't know whether you allow me to clarify my my mimics on the previous two speakers, depending on time. Just on Mike, I mean, I think we'd all love to see a European company emerging that would then qualify as the 600 billion gatekeeper. We would love it, and it's a bit of a shame that we spend a lot of time and resources of all those bright people on the regulation, but it's necessary. The other part is not discussed here, how to make the European digital economy flourish. That's for sure. Where I would disagree with you is on what you said, the fierce competition. You're right. I mean, this is not railroads. Absolutely agree. But once you buy an iPhone, you're locked into a specific system, and there is no fierce competition for you as a consumer with another app store. So basically, Apple curates and does a good job. But we talk about, when we talked about sideloading before, as Lisa has said, I mean, we talk about something that at least has been possible with a Mac. And why to us there is basically no question that this can obviously also be technically possible for the App Store. So in that regard, the provision is from our point of view is also absolutely okay. And maybe a final point that's now really going back to the remark on the ex ante regulation. I mean, we know that this is the speak that has been in the debate for the whole time. But just to clarify, we think that the DMA is no ex ante regulation like in telco law. It's self-executing provisions. It will have a sort of de facto ex ante effect, because the gatekeepers will be forced into a dialogue. And we've heard a question also from the gatekeepers saying that we need competent people because this will really go into our business models, and we need to get decisions on whether we can introduce new services, things like that, very quickly. And then that also now goes back to the initial question on what about complaints. Again, I think as Mr. Schwab has said, for us, it would be really, we think it would be a good idea to draw other resources from the member state level into that as well, because sometimes people have good lawyers, the resources, and to immediately go to the European Commission. And maybe other firms, as we've heard before, are investing 99% of their time into development, and then they maybe can just send an informal complaint to a national competition authority.
Thank you for clarifying that. We'll turn now to on all of this, Rebecca. I don't know what are your thoughts here. So let's talk about go back to the obligation side. So once a core platform service is considered to fall into the scope, and we'll have to implement all those obligations in general manner without different specification. The company had indicated previously that this impacts this approach, might guarantee speed, but in some cases could prove disproportionate. So I was wondering if you could specify why we should not follow this one-size-fits-all approach, and how we can maybe strike the right balance between preventing harmful practices, but at the same time maintaining all those benefits from the online economy that Karim and Lisa mentioned.
Thank you, Morgane. That's a very important aspect. Because as of now, the obligations are kind of, yeah, they all apply if you are considered a gatekeeper. So there will be a few companies that will have to comply with those 18, I think, 18 provisions in the DMA, in Article 5 and 6, and for all of us who have been active in the competition environment for a few years, if you look closely at those obligations, you can kind of see specific situations and cases that have happened in the past. So each obligation is kind of a mirror of a competition case that has happened in the past. And all those competition cases, some of them are not decided yet, but all of these cases, of course, center around one specific company. But all those companies that are or were targeted in those competition cases have different business models. So if we mirror obligations that were obviously intended for a specific business model for one of the largest platforms, and put them all together, and then force all gatekeepers to comply with all of those obligations, that might be kind of over-regulation, to be honest, because a provision that makes total sense for the business model of, I don't know, Facebook or Amazon or Google or Apple or Microsoft or one of the others, it might not be very accurate to impose the same obligation on another company, because the business models of the platforms are very, very different. We kind of like to put them all together in one basket because they're all like huge, but the processes and the business models are very, very, very specific, actually. And a remedy that is tailored for a very data-driven process might not make sense for companies that is a marketplace, basically, and vice versa. So we think it would make sense to build a system that can impose some, you can call it ground rules, basically, for all the gatekeepers where it makes sense, to ensure fairness of the market and contestability, but all of the other obligations should be tested against the business model that they are trying to regulate, to see whether it makes sense, to see what kind of consequences will happen if we impose specific obligations or remedies. We are still debating that internally as well, to be honest, because as the platform systems are often so interconnected, all the consequences are not clear yet. But we think a more tailored approach, or some kind of a 2 or 3 step system, could make more sense. And then, depending on how well the regulatory dialogue goes, we might end up with a system where the obligations that are imposed at the end on a specific gatekeeper creates a better system without harming players in the market that we did not intend to harm.
Thank you very much for clarifying this. I'm going to maybe have a last round of questions before finishing this webinar, because we're running short on time. I'm going to turn back to you again, Dr. Schwab, and maybe on the speed of intervention. We've noticed in the draft report that many of the timelines in the DMA have been shortened since the initial proposal. And so, while larger actors may require less time to react to these obligations, smaller actors, even though they're very agile, don't necessarily can adapt as quickly and harmed by shorter timelines. As you mentioned before, they have other things to do as well than to go and complain to the competition authorities. So, for example, if a gatekeeper passes down some compliance costs to smaller ones, they experience new harms. So, what safeguards do we foresee to ensure that these changes do not move too quickly, cause negative consequences, but at the same time that we do have sufficient speed? So, I think it's the whole balance in the DMA.
Well, that's a very nice comment that you have done at the end. That's the whole balance in the DMA, but to achieve the whole balance, that's the key problem. And your introduction to that final comment was a bit contradictory, because you have spoken a bit against the fair balance. So the problem is that if we see, not we, but if the European Commission will see that there is a strong imbalance in the market, then we cannot think first on all the app developers that are part of the company that has created that imbalance. We have then to think first on the market and on the contestability of the market. But I mean, Mike has spoken a bit in favor of the app stores, and well, that's okay. But I mean, we also have never had the idea now to destroy these companies. and they know the problems they are facing. They are speaking to the European Commission since years. And therefore, I mean, if the rules that we set, and I think Mr. Käseberg has used a very nice example, the gatekeepers will be forced in a certain sense to ex ante dialogues about these principles that are laid down. And then there will be in every app store, there will be some questions that are a bit sensitive. I could now outline them to you, but I think I will leave it out because no one wants to destroy them. And I would not even say that the key reflection is now to create a European one or to hope for a European one. I think these companies are quite smart. And because of digital transfer of data, they know very fastly what is the problem that they are facing and how to fix it. But still, maybe with investment conditions getting better in Europe, maybe we can also achieve this. But we are not doing that against anyone. We want that to be done in the interest also of the stores, because if they are getting fairer, they will also offer other apps to be there. And like that, the balance, as Morgane has said, the balance in the end is important. And therefore, if you see in that sense, the balance not being achieved rightly with the DMA in its current form, please don't hesitate to come back to us, because for sure, that's what we are aiming for. We want to find the right balance. We don't want to destroy anything what works well, but we want to make sure that contestability is all the time possible. That's nearly impossible to achieve both goals, to be honest. That's the aim only. And to that aim, we do the DMA. And in the end, it's up to the European Commission to follow the markets, to see the complaints of SMEs, of app developers, how they are blocked in one, how they are treated in the other one, what could be done to improve that. And as the idea of the DMA is that because these principles are quite vague, that there is a compliance need for these companies to cope with the do's and don'ts. And these companies are all in a democracy, in the biggest democracy of the Western world. So there is no problem for the officers there to look for compliance. They will maybe also come back to us with very smart ideas on how to apply these ideas, these principles. And therefore, I think we should also be a bit positive about the future. There is, let's say, the key principles on the table. Rebecca was right that you cannot easily transfer from one company to all of the other companies. Yes. But still, the principles in themselves, they are not wrong. And if there are the Americans now moving on with this in the same pattern, I think we have also a chance that just by compliance of these companies, that will be done on the basis of 5 and 6 of the DMA, we will even get from them some good ideas on how to be compliant. And like that, we should be very careful. And that's my last comment. I always see you, Morgane, here in the big screen. That's the reason why I address all the time you. I think we should be careful that the companies should not declare after some months we are all compliant. That would be a bit dangerous because they are not at the moment. But it's not only because they want to cheat. It's because the businesses have developed so quickly, so fastly that it has been brought a lot of money. The shareholder value reflection with the shareholders is there, and therefore they are also a bit under pressure. So therefore the right laws can also make these companies to behave or not to behave, to work much better. And that can then again help the app developers. And therefore we have sped up a bit the timelines. We believe that the gatekeepers that have always so many lawyers here in Brussels hanging around, they can spend 2 or 3 of them to work a bit faster. There is no problem. And I mean, the Commission can always grant the right to be heard. The Commission can always make longer timelines if needed. But what we don't want to see anymore is that we are cheated. And I tell you something now, and you should not think that we are naive. When I was the rapporteur on the Network and Information Security Directive, there were plenty of American companies coming to the European Parliament, explaining to me what they think about cybersecurity and so on. And one of them, I don't want to mention the name now, but rather a small one, but you know it all because it has a very colorful logo. After some meetings, they have showed me the number of clicks over the years. And you will be surprised, they were quite high. And 2 or 3 times per year, they were falling down on 0. And I said, but strange, this is the holidays cannot be only one day. That is very strange that you fall on 0 2 or 3 times per year. Yeah, they said, yeah, that's a problem. And I said, but how can it happen? And then they have put on top on this some algorithm changes with search engines. And at that moment, when I saw that the change of algorithm has always led to a 0 click time with this other company, I have understood that this is not algorithm, although there was Karim from the company doing all that. This is a business practice. There is no rocket science behind. This is just a cash machine. You channel the money into your own pockets, and that cannot be given us anymore as an explanation. It's the algorithm, stupid. No, we will tell them it's your business, stupid. And this is something that we do also in the interest of app developers, because also these apps that have not been getting any more the clicks have been developed by young people and by bright people, and they don't merit to be treated like that. There has to be some sort of fairness, and we have been cheated for too long time, and that's finished now, forever. And that is the principle that we defend. We don't want to destroy anyone who wants to contribute to improve the market. And for sure, at a certain moment, there are also fair economic choices for companies to take individually. But what we have been seeing in the last 10 years was something else. And no one should close the eyes in front of this. No politician, no app developer. And if our meeting was constructive today, I think that's the conclusion that we should do. You have a task to do your business. And if you see that there are people in the business that mistreat you or others, you have to speak out. And we have to leave you to do your business. But if we see that there are wrongdoings, we have to intervene. That's the logic. And I hope that we get it right.
Thank you for your passionate remarks, and I think sort of fairness is the key. So what I'm going to do now is just ask all the panelists, or the other panelists, to at the same time closing remarks and maybe to react. I'm just going to jump to maybe the developers first on my initial question on reaction time for somebody, a small business. How does it work when a platform changes practices? How long does it take you to understand all of this? And maybe wrap it up with your closing remarks as well. Karim, maybe you can go first.
Sure. Can you please repeat the question? I wasn't hearing it properly.
I was just asking you to react maybe on if you do have somebody in your company that follows EU legislation, how long does it take for you or your company to understand all the different changes that have been happening? And for example, if a platform, let's say, is forced to change the business practices, how will it affect you, and how long does it take you to understand and to adapt the different stores?
Yeah, so if I understood it correctly, you mean when there's a different platform, how it affects us in terms of the update cycle?
Your reaction, I would say reaction time in general for an SME, what does it require? But I mean,
yeah, so
you don't have to.
No, like I said, to us, and with the given fast pace of the whole, I would say, app economy, to be competitive, I think that's one of the reasons why we've been ahead of the curve, is that we're very, very fast and very lean. And we took a conscious decision to really minimize the places where we offer our app, because every place we offer the app, it just means more complexity, increases the risk. And to us to really be able to innovate, it just turned out that, focusing on reducing complexity, because we came from an era where there was like maximum complexity in all areas for software distribution and marketing. And we just realized, and it's very clearly reflected in our revenue and profitability, is that reducing that friction and especially maximizing the security is key for our business success. And the one thing that's really important to us is that, this whole developer perspective is really taken into account, because if you see, that's a slightly different example, but in the music industry, when this whole digitization came and, there was Napster, and it was just, it had huge implications on, piracy of music and those kind of things. So it almost destroyed an entire industry. So obviously that's very different here, but still I think all of the implications should be taken into account, both from a developer and a user perspective.
Thanks, Karim. Lisa, do you want to do some final remarks?
Yeah, I want to shift the focus a bit on the developers, on the great community they developed, and I want to point out that these are very kind and loyal people, and you as a from the big tech side, as also from the politics side, you have to treat them fairly and kind, and respect their work. So doubling, tripling, whatever their work is, will impact their, for example, their feature roadmap. There will be a delay of the of improvements, developments, new ideas. Also, as I'm long enough in the market, in this development area. Professionally, I'm also married to a developer, so I can clearly say that if you have to adapt the new system, if you have to react to a security breach, whatever, it clearly affects your whole life, your family, your children, and in the end, it will affect your mental health. So we should consider that when we bring new regulations.
Thank you. So indeed, small developers are often a 1 or 2 people operation. That's often the feedback we receive from developers. I will jump to you, Rebecca, if you want to react to anything that's been said. I know we're running a bit short of time to continue the discussion on other aspects, but
I'll make it quick, Morgane. Let's just keep talking. I think that's the most important thing. As we have seen today, there are many different aspects that have to be taken into account. There are many perspectives that play a very important and intricate role in the digital ecosystems, and all of them have to be heard. So thanks for making it possible today. It was really a great discussion in my view, and let's keep on doing that.
Dr. Kaiserberg, any reactions to the previous discussion?
Yeah, on your reaction time point, which sort of runs through the whole DMA and overall discussion. I loved Andreas Schwab's passion. I mean, there have been statements by founders of Silicon Valley firms actually questioning whether the state and politics can keep up with the pace of innovation and dynamics of the market. And just to be frank, I mean, this is now the answer. If we really want to, and that's what has been said before, we don't talk about railroads, but we talk about really fast-changing dynamic markets. And if Mr. Schwab has proposed to shorten our regulatory dialogue, it makes to some extent, it makes sense from our point of view, given the experience that we had over years, that those companies, for business reasons, are just always dragging their feet. That's okay. So as a legislator, we have to identify harmful strategies that are harmful to other market participants. And if then we find good procedures that cut down the reaction time, in those cases, it makes sense. So I see your point on cutting down the arguments that gatekeepers can bring forward, but that's just the mirror image of what has happened over the last couple of years.
Thank you very much. Mike, do you want to react to any other thing? If you have one last word, what would you want to share?
Well, I think this was a very passionate and fascinating discussion, and I think the main difference, you know, if you look at the previous generations of regulations and in tech, you know, the difference between PCs or Macs and these phones is that these phones are the most personal devices that we've ever had. You know, we store health information, we store the photos of our loved ones, It has a microphone and a camera that we bring in every room where we go, pretty much. So including our bedrooms and our bathrooms and everything else. So this is a very important part of our lives. And we have to make sure that, you know, whoever the users are always protected from harm. And, you know, this is one area where I think sideloading, you know, raises a lot of questions. And without any kind of review process, if apps end up stealing data or violating trust, then people will be much more hesitant to install apps from sources that they are not familiar with. And that would end up essentially only benefiting the really big brands, and the small independent developers who don't have a brand would not, you know, have the opportunity to compete on a level playing field. So I think Rebecca said, we need to continue this conversation and keep talking. And once again, I am so grateful to Mr. Schwab and Mr. Kazem that you were here and part of this conversation. Thank you so much. And, you know, we look forward to continuing the conversation in other forums.
Well, thank you very much to all of you. I think it was an extremely interesting discussion, a passionate one. I think we've heard many things, that we need more personalized approach to the DMA. We need more resources at the national level to enforce the DMA. We need more fairness, consumers and the trust and the ecosystem need to be taken into account. So let's continue the conversation. We'll have our next AppMakers tour focusing on France in July. So I will share this with all of you as soon as possible. There will be an interesting discussion as well. So in the meantime, I hope you're going to enjoy the wonderful weather outside for those that are in Brussels, and have a very nice afternoon. Bye. Thank you.
Thank you, Morgane. Bye-bye.